welcome to our first deep dive episode of Babies on Backorder. This week, I had the privilege of interviewing Professor Andrew Dzeguze, who will have more of an introduction during the interview. This interview happened on November 14th, 2024 in the town of Flagstaff, and I'm excited to hear your guys' feedback and commentary about the difficult subject that is the law surrounding reproductive rights, especially IVF. Anyways, let's get into it. I'm here with Professor Dzeguze of Northern Arizona University. He's an esteemed professor in the pre-law program here with expertise in constitutional law, American politics and government, and judicial politics. You have mentored people close to me and taught other members of this podcast, and each of them has spoken highly of your ability to explain policy and legal processes to those who know very little. But thank you for joining us. Before we dive into any questions, is there anything else that you would like to add to the introduction?
No, just to clarify, I'm in the Politics and International Affairs department, and then I'm the pre-law advisor for PIA. Calling it a pre-law program is probably being too generous. You know, we have a bunch of different people who teach legal subjects around the campus. So just in case anybody wants to go find me on the website, look under PIA.
Gotcha. Thank you for clarifying that. The first question I have is,
Sure.
what is the current legal status of IVF in Arizona? And are there
Sure.
any active legal challenges that might impact the access in the state?
As far as I'm aware, IVF in Arizona is legal. As far as I'm aware, there's none that are to the level where like I could look at it and say, you know, this is definitely a thing. I'm not also aware of anything that's really challenging it in the federal system. The way, for example, there was a direct assault on mifepristone's FDA clearance. I'm unaware of anything like that. Obviously, this got into the news because of the case out of Alabama. But that case, if you've investigated or if you've talked about it other ways, was really a weird backdoor into this issue because it was a destruction of embryos done by somebody not in the clinic at all, someone who was unauthorized to be there.
Okay.
Apparently someone who was upset about their own situation. Then it was the clinic being held liable for damages related to that led the Alabama courts to say, oh, we're going to adopt the concept of fetal personhood to determine how much you owe in terms of damages. In other words, instead of treating them as property, which would have had a lesser value, they treated them as people. And that is what has triggered this concern, because there has been this long movement and this goes all the way back to Roe. So at the same time, there's this movement all the way back in the 1960s and 70s to have fetuses and embryos declared people with all the rights of people, which in turn would make something like abortion or IVF, where there's selective destruction of embryos, murder. So on the one hand, I'm unaware of any like concrete pending legal challenges that I could point to, but at the same time, there's this background legal dispute that's not going anywhere, and it's been going on for, like I said, more than 50 years at this point.
Certain interpretations of Roe v. Wade could have effectively shut down any of the challenges, or if there were no laws within that addressed IVF.
So interestingly enough, what Roe did is duck the question of where life begins. There's literal language in the majority opinion from Roe that says, this is something on which there's no consensus. It's way too thorny of an issue for us. What we do know is, and this is what they balanced when they adopted the trimester framework, was that the state has some interest in the preservation of life, but that a woman, as they phrased it at the time, I guess today we would say person capable of carrying a pregnancy to term, also has a right to privacy. And those are the two rights that they balanced. You're looking for something in that language where they were clearly like, this is a fetus, it's property or anything else. They did not go there. They actually made a point of avoiding that question. And they never said, and that's why viability became kind of the magic linchpin in Roe. Because viability, that is the point at which the embryo can exist outside of the womb on its own, which is obviously an ever-changing technological question. Once it can do that, then the argument goes, well, then the state's rights are greater because at least in theory, that's now whatever it was before, it's not as dependent on the mother. Therefore, there's more justification for the state to step in. But again, like I said, it's kind of shocking how far they go to be like, yeah, we want no part of this.
Yeah.
Because interpretations of Roe by other people later and kind of lay interpretations are like, oh, life begins viability or something like that. They did not want to get into that debate at all.
Is that something that you think should be left up to physicians?
As a personal matter, I think what the court's wisdom was there, and this is one of the things that's frustrating about Roe being swept away, is their wisdom was to not get into things there wasn't a consensus around. To recognize that their role is not ultimately to be an arbiter of this. Now, that still leaves it open, and that's why cause actors have seen it. Is one way to read that is, okay, well, what if there is a consensus, i.e. reflected in state laws, that does this? And so your broader question of who should have the right to decide what medical care is, that's actually an incredibly thorny question. It has always been the case. I mean, we're talking going back to the ancient Greeks, that there is a public component of medicine. At the same time, there is a strong view, and a strong view in the American legal system in particular, that for the most part, medical choices are state level decisions, not federal level, because they're more part of the general welfare of people rather than specifically linked to the Constitution. But also just more generally, that medical choices reflect this, and to get into kind of your core questions a little bit, the ones you sent me before, it gets into this question not so much of bodily autonomy, but individual right to make decision making. So it really starts with the individual as rights bearer. And then if I'm an individual who has a right to direct where my life should go generally, then I should be able to consult with physicians to help me make those choices. But the state should be minimizing its intervention with that. Now, again, the reason I want to say that at one level, there's always been this concern, and this is a whole deeper, richer history you can absolutely explore. I don't know how specific this podcast is, but the history of the licensure of medicine in this country is a whole other deep can of worms, and especially when it comes to things like reproductive care. Because if you went in as late as the 18th century, right? So the 1700s, the 1800s for most of it, most people, when they gave birth, at most they had a midwife, or their care all along their pregnancy was an elder who had been through it, who had been trained, who understood things. It wasn't really seen as physicians' involvement was very minimal, and it was only at these like elite levels of society. But once you started seeing the standardization of medical training, once you started seeing things like med schools, along with it came this push for licensure. And at least one strain of that was to get women who were excluded from the practice of being physicians out of caring for other women. That's like this whole, so like I said, licensure is always this push-pull. On the one hand, it's always supposed to be in the public interest, to preserve health, and like I said, that goes all the way back to Hippocrates. That goes all the way back to this concept that medicine is supposed to be this baleful thing, and therefore this good thing, and therefore society has some interest in some measure of making sure it's still being good for good. Okay, that's where we get things like some of the earliest federal regulations of drugs, for example, were to make sure that, when you buy medicine, it's actually medicine and not just vodka. It's not just straight alcohol that makes you feel good for a while, but is killing you slowly. That's where that idea comes from. And actually what like the FDA is set up to do, and their standards are supposed to be, if they're regulating something, does it actually do what it says it's going to do? And is it safe? Like that's the two watchwords they go by. But they don't, or at least they're not supposed to, dictate what a doctor can or can't do once those decisions have been made. So it's supposed to be from that like general promotion of health standard. I know this is a long-winded answer for this question, and I'm afraid a lot of them are going to be, because you're asking some really, really deep stuff here. But that's really where medicine, that's the issue you run into with medicine, is on the one hand, like I said, we have this ancient idea it should be promoting health. And therefore, if it's not, the state may be able to intervene. But at the same time, it's supposed to be this very, very light hand. It's not supposed to be coming in and saying, okay, you can only do tonsillectomies on Tuesday and only in, these really confined situations where, most people are not going to be able to get it. And the reason I bring up something like that is because I think that illustrates what makes IVF, what makes abortion, what makes anything having to do with reproductive health so different, is because people's values get caught up in it, they tend to see it through a much different lens. They tend to see it as, and so they're much more willing to be heavy-handed in regulation, because it goes back to these ideas. This core concept is, where does life begin and who has rights in that setting?
The next question I had is, how do you view the role of legal protections for IVF access for families unable to conceive naturally?
So if you start with that, so the really fascinating thing is that there is no right to privacy in the Bill of Rights, not overtly. So on the other hand, Arizona, for example, does have an explicit right to privacy. Whether it covers medical decision-making or not, until this recent initiative was passed, was actually unclear, because while we had this right to privacy explicitly granted, it had been interpreted as being more like, your right to have private conversations, your right to have your private business and your property be respected. But medical decision-making, generally speaking, is an emanation of that sort of that right to privacy. Where that comes to us from, and this is a deep thing about the history of the court. For the first 180 years, nobody on the court was talking about privacy. Okay, and then they started talking about it. Well, actually, 180 years. It was about 150 years. So in the 1920s, in the context of wiretapping of all things, okay, the court started debating the question of whether you have a right to privacy or not. And this was a case called Olmstead. And in Olmstead, the FBI didn't go into somebody's home. They tapped the wires leading out of the home. True wiretapping, okay? The majority of the court at that point said, they didn't come into your home, they didn't disturb your papers, no problem. But a dissent started saying, well, government shouldn't be able to go everywhere. There should be a zone of privacy that the government can't intrude with. And these reasons, and I want to say it's Justice Brandeis, but I could be getting that wrong. But I do think it was either Justice Brandeis or Frankfurter. Those two are linked to kind of starting this out. And they even wrote law review articles about it. They were very forward on this idea of a zone of privacy. Now, that idea, in turn, is actually rooted as much as anything, not so much in our Constitution, but in J.S. Mill's concept of liberty. Okay, so J.S. Mill is this guy in the 19th century English philosopher. I don't know if you've had to read any of his work. He writes a real strong defense of capitalism, for example. But he also writes this idea called On Liberty. And what he says is that in the truly private sphere, anything consensual adults do is off limits to anybody else. Anything so I, again, as a rights-bearing individual, which goes all the way back to John Locke and the Second Treatise of Government, which heavily influences our Constitution. Okay, our Constitution literally steals ideas from John Locke. So does their Declaration of Independence. So it says you have certain rights like life, liberty, and property, and those can't be taken away by the state, generally speaking. And that's where we get things like the concept of due process, that the state can't deprive you of life, liberty, or property without due process. So that's where we start from. Well, Mill then digs into, well, what does this thing liberty mean? And to him, liberty is basically the right to make private decisions for yourself and private action. And where he says the state can't intervene unless you're either in public, which he has this public-private dichotomy, or are you doing things that are at risk of causing imminent harm to others? And so that's really this 19th century idea that then gets picked up in the 20th century. And that is really what becomes sort of the basic idea when we first start talking about a right to privacy in this country. It's in the context of, can the state intrude? And what they come up with is a test that says that if you have a reasonable expectation of privacy, okay, which can vary and float depending on where you are and who you are and whatever else, that the state, generally speaking, doesn't have a right to intrude unless they go through due process, get a warrant, do those kind of things. That's the first place that we start talking about it. But it comes, and that comes out of this idea that we have this Fourth Amendment right to avoid unreasonable search and seizure. So that's part of it. And that's why it really matters in a criminal context. But we also have in the First Amendment these rights to engage in conscience, these rights to think as we will, to act as we will. And really, it's the marriage of those two that become this idea that you shouldn't, that the state, again, the government is who we're worried about here, not private actors, that the government shouldn't be in a position to, interfere with those private decisions, because it wouldn't be much of a right to free speech if you couldn't think for yourself, or that the government could always intrude on that. It wouldn't be much of a right to association if the government could always know exactly who's in your house at all times. So that's kind of the blend that you have there. Okay, is those two are kind of the backbone of it. And so this grows into this idea that we should have privacy around all these sort of intimate choices that we need to make. And how it gets extended to things like doctors is, so I don't know if you have looked at, or anybody on your podcast has looked at Griswold v. Connecticut. This is the big linchpin. This is the pre-Roe linchpin of the concept of medical privacy. So Connecticut had this goofy law that said nobody can buy basically condoms. Nobody can buy birth control. Okay. They weren't enforcing it, but it scared people away, and it scared drugstores and pharmacists away from offering contraception. So it got challenged, and it took them a while to get the challenge up because, again, nobody was threatening to enforce it. But what the court eventually had to face was this really kind of ridiculous law that was saying married people even couldn't engage in family planning. Like, they just had to have as many kids as happened, right? So the court in there is then confronted with, okay, we really think you should have a right to talk to third parties about these intimate life choices. So what they start with is this First Amendment, Fourth Amendment concept of your right to, decide who you're going to marry. And as part of deciding who you're going to marry, that's a very intimate choice. Deciding how many children you should have, deciding how you're going to raise them. By the way, that was another thing that had grown out. There were some cases in the 20s and 30s that said things like you have a right to make sure your kid could learn foreign languages. That's considered an ability to direct your life, right? So the state can't stop you or force you to do certain things. So it kind of grows out of this idea, and that's where they recognize this right to privacy, this right that you have to think for yourself and do for yourself, and again, do things like get married. And it has both due process implications and equal protection implications, both areas. Then that is what, okay, well, these decision makings that you have to make that are so intimate might require you to talk to a third party. And so the right to privacy gets expanded to people like doctors. Okay, so that's really where it comes from. That's Griswold. And then Roe just builds on that by assuming there's this right to privacy recognized in Griswold. And what does it extend to? It extends to these choices about reproduction. And that's where production for IVF, to the extent it exists, that's where its roots are, is in something like Griswold.
Would that be the origin of HIPAA?
Yeah, kind of, HIPAA's obviously a different piece of legislation, but the mindset, yeah, because HIPAA's kind of coming at it from the other end, because normally business records aren't private. So like, your choice to go get a job is an individual choice, but once you go and make it and you have a bank account, that bank account, that's public. Not public, okay? But it's not private and intimate in the same way. So normally, if the government wants bank records, they don't have to get a warrant. They just have to get a subpoena, which is a much lower standard. Okay? They want to get your internet records, for example. There's some statutory protections, but generally speaking, it's not seen as the same as coming in and reading your diary, or coming in, in other words, it stops being your record once a third party is involved. And so it's making sure that, and HIPAA also expands it because it makes it so that it's not just the government can't get that information. It's that nobody should get that information who's not authorized to. But yeah, that's the same idea. There's this deep-seated idea that there's some things we do that are private. And sometimes, even though they're private to us, we have to go talk to other people. We have to do other things. That's why we recognize things like doctor-patient privilege. So they shouldn't be able to get your records and discovery of when you're telling your doctor why you feel bad. All of that comes from that same sort of idea, though, that it's you as the rights-bearing individual. You're exercising your rights. You should be able to exercise your rights, and that's how we do it. Now, what's really interesting about Griswold is they squarely recognize there's this thing that's not written explicitly in the Constitution. And a couple of members of the court said, let's invoke the Ninth Amendment. Let's say that it's a right that's never been enumerated, but we all recognize people care about it. But because the court standard for when a right is fundamental to you is it has to be, quote, deeply seated in our system of ordered liberty. Okay. In other words, it has to be something we think we would cease to have a system of ordered liberty if you were deprived of it, because that's their standard for that. Most of the members of the court were not comfortable and have never been comfortable with recognizing a right just because it's important. In other words, they're not going to, even though the Ninth Amendment says, just because we wrote this list down doesn't mean that's all the rights you have. They have never relied solely on it to come up with a new protection for people or recognize that there's always been this protection. We've just never articulated it. And that's probably one of the huge weaknesses of Griswold is instead they have to argue, well, the First Amendment gives you these rights, kind of, sort of. The Third gives you these rights, kind of, sort of, because the Third prevents the government from sticking people in your house. Okay. And the Fourth protects your property. And the Fifth protects your right against increment. So they wind up writing this goofy language that says that it's not the rights themselves, but rather the penumbras, okay, the emanations. That's literally the phrase they use is emanations and penumbras. So if you look at the rights, they're not just the text they are, but rather kind of a halo that forms around each of the amendments. And they stick four of them together and they say, well, when you link all these together and you see how they overlap and you see what they were worried about, that creates this thing called the zone of privacy. Okay. I will say conservative members of the court all the way back in Griswold thought it was goofy, didn't like it then. There's been a movement to get rid of it ever since because it's not written, it's not clear, it's not in the text. Think of your own reason to do it. And similarly, when they wound up attacking Roe, the way they attacked Roe was they changed the question. The question Roe asked is, does the right to privacy that we recognized in Griswold extend to a woman's right or a person's right to consult with a doctor about terminating a pregnancy? The way Dobbs phrases the question instead, and this is what makes it all so slippery, is there a deeply rooted, remember how I said a right has to be deeply rooted in our history and traditions? Well, is there a deeply rooted right to abortion? They phrased it that way. Well, if you phrase it that way, and like I said, the practice of medicine wasn't even really licensed until the mid-19th century, and you go back and say, what were people saying in the 18th century? Well, of course you're not going to find an explicit, deeply rooted right to bodily autonomy. Of course you're not going to find it because you've rewritten the question. Now, again, you could look at that same evidence of people's concern about privacy and say, well, absolutely, it was deeply rooted. It's all in how you phrase the question.
Building on wording and interpretation, I read your published work, The Devil in the Details, and you mentioned how small changes in wording can lead to big changes in interpretation. How do personal beliefs about personhood influence wording in legal interpretations and ultimately decisions in reproductive cases?
Well, I think that's the first question that you always have to get to. One of the things that's hard for students to wrap their heads around. And I know when I was an undergrad, law feels attractive because it feels like it's not driven by emotional considerations, that it's driven by quote unquote rationality. But certainly the more that I got into patent law, which is where I come from. I mean, what you read about is, about patent law, right? The more I did this stuff, the more I actually practiced law, it's less about my views about personhood and more about my views about just the inevitability that all the decisions we make are necessarily driven by or influenced by who we are in the first place. Now, that doesn't mean that we can't set aside like obvious bias. In fact, one of the reasons that I argue and have argued in other places in conference papers and in my dissertation and stuff, one of the things that I've argued about is that judges should be more aware of these biases so they can surface them and ask themselves, am I doing this because it's the right thing, or am I doing this because it's Tuesday and I'm grumpy, or because I was raised Catholic, or because I was raised in an agnostic household, or I was, or because my best friend in high school, was dissecting stuff all the time. And so I have a different view of biology than other people do. I mean, there's a strong argument that Roe v. Wade, for example, comes out the way it does because the guy who authors it, Justice Black, not Black, Blackmun, sorry, Black and Blackmun overlap at the court. Blackmun is from Minnesota, and he happened to knew people at the Mayo Clinic. So he went home and he consulted with doctors at the Mayo Clinic. So if anybody else had been assigned that opinion, who knows what it would have said, right? So it's not just my views, it's not just anybody's views, but that is one of the things that I've come to believe is that in the world of thought, law is very much a constructed thing. We're building it collectively. We're building it, and so because human beings are not fundamentally capable of completely divorcing themselves from their influences, it's really irrational to expect the law to be that way. And what's interesting is some of the most conservative members of the Supreme Court have recognized that. They just have taken it and used it to other ends. Like Scalia overtly was like, yeah, I know there's racial prejudice out there and you're never going to get rid of it. He wrote this in memos. He was like, you're never going to get rid of it. So why try? As opposed to maybe arguing, that was in a case involving capital punishment. Instead of saying, well, maybe it's inevitable, so we should try to work to build a system that minimizes it. And that's a real debate amongst lawyers, is first you acknowledge it in the first place, but amongst legal scholars is once you acknowledge it and you acknowledge that law has to work within a societal construct, then it really does become an open question and going back to that first question that you had about IVF, if enough Americans had a consensus that those things in petri dishes or those things in test tubes are fully fledged humans, then the law probably wouldn't stand in its way. In fact, the law would reflect that because the law inevitably reflects some version of our societal consensus about what the world really is and what it really means. I like very much to think that my view of the law is because it has to work for most people, that we should therefore be cognizant of who it's applying to. And one of the things, again, to go back, since you did raise my personal journey, one of the big things I think that has changed for me over time is because of who I was, because of what my identity was, because of how I was raised, it was really easy for me to be blind to how slanted the law was and how much it reflected cultural norms that were just accepted for me, but would absolutely be a smack in the face if I was born with different chromosomes, if I was born with a different skin color. My father's an immigrant, so I was raised with this very big belief that America doesn't care where you're from, that America isn't biased against you, that America just cares about whether you believe in its creed or not. That's certainly what we aspire to. But at the same time, when you study something like the actual history of immigration law, or you study the history of again, drugs, right? Why is alcohol legal and marijuana a Schedule I narcotic? Well, that's cultural bias more than anything else. So why don't we have? So again, it's this, all of law is this cultural construct, and I guess what I've really become aware of, and what I am very concerned about, is when implicit assumptions about what's quote unquote normal then get imposed in the law in ways that have predictable outcomes because nobody's surfacing them. So I don't know. In some ways, I'm a big believer that government can do good things for people, but at the same time, maybe I'm a borderline libertarian where I'm like, but they should only do it when there is really a consensus and you're really surfacing these concerns, because we do a lot of things. We just do a lot of things, and a lot of our laws just don't ever examine why we assume these things are true. And so to get back to the question of IVF, like I said, if we were the society that we were at, say, 100 years ago, I can all but guarantee you that IVF would be under attack because it would be seen as tinkering with God's work. It wouldn't even become accepted medical practice, much less be protected by the law. Because that's back when, people made it a crime to teach Darwin. Again, and it's not that it's an invalid choice, it's just that we oftentimes don't surface it. In fact, if anything, fear of a law being struck down under the First Amendment, under the Establishment Clause, stopped people for about 20, 30 years from there about being honest about what their motivation was for doing a lot of things. Now with the current court, they're probably less concerned about that. They're less worried that somebody's going to see it as wrong to establish it based on God's will. And so you're probably going to see more people openly saying that, because you're seeing more and more politicians say, well, really, there's no real separation of church and state. We can still fundamentally use things on Christian principles. So you're going to see more overt statements like that. And I don't know where it goes with that. But at the same time, at some level, they're not wrong in the sense of, if there was a true consensus, if there really was a consensus like that, then the law, that's what it would do. It would ban the procedure. It would ban, a whole lot of things. I just don't think there is such a consensus.
You earlier touched on beneficence, and I was wondering if you thought that the law reflects beneficence for families seeking help with reproductive services.
Some do, some don't. Some are absolutely just about punishing people for doing what is out of the norm. I mean, so if you look at our criminal justice system, it is largely, not exclusively, but it is largely about control. And like I said, that's probably the place where most acutely you see examples where our social construction of what's normal leads to us putting criminal sanctions on people for noncompliance with norms they have no chance of complying with. This is, criminalization of mental illness, basically. While claiming we're not doing it, we do. We criminalize mental illness. We criminalize genetic predispositions. We criminalize all kinds of things because they don't fit in with our norms. So I don't see much beneficence there. I see control and protection of the people who easily can comply with the norms at the expense of those who can't. All underlying an assumption, again, this John Lockean assumption that you, I, everybody else are rights-bearing, atomistic individuals who, therefore, if we really wanted to, we're all equally capable of complying with the law. So therefore, if we don't, we are presumed to have done so by choice. And as a result, we deserve punishment for violating those norms. There are other places where I think the law seeks to do good things for people's lives. Obviously, the welfare state tries to do that. I think public service, for the most part, public administration, things like water treatment, things like public goods, roads, these things, they're meant to be beneficial for society. We overtly try to do that, for example, when it comes to children. Okay. If you look at the laws relating to things like child custody, if you look at the laws regarding to child welfare, if you look at the laws relating to education, vocational rehab, special ed, they all come from a place of, we're trying to do what's in the best interest of the child. And that, again, is also this sort of rooted in this Lockean conception that children are these empty vessels, they're blameless, they're, so we want to protect them. You can see that in, the policy protecting dreamers, right? It's that they're blameless, so therefore they should be protected. So you see that, but it also comes with this pre-existing judgment that you have to be deserving of beneficence. You have to be deserving of, or at least not guilty or culpable. And so we're much more willing to do that than we are. And it also comes down to things like programs in the law where you see opportunities for diversion, opportunities to avoid criminal punishment. They almost always have a class and racial bias that in turn is tied into judgments about who's good, who's worthy, who's deserving, rather than being sort of a radically compassionate system of, we believe in the good of everybody until they prove us otherwise. We don't have that. At least I don't see much of that. Again, like even something I mentioned the welfare state and how it's trying to be good, but you have to either earn it, like Social Security is a perfect example. You either have to earn it by being an employed working person in the quote unquote legitimate economy. Okay. So if you've been forced by circumstances to work in the underground economy, then you don't get Social Security. You can get cut off from it by being in prison. You can get cut off from all kinds of welfare benefits based on criminal history. If you weren't able to work for a variety of reasons, you can't do it. If you have substance abuse, for example, generally speaking, and you can't work for that reason, that generally you're never going to get the qualifying credits you need. Now, we do have a system for people who can't work, and that's SSDI. But to do that, you have to show you are disabled. And in most cases, those disabilities, again, you have to show you're blameless in them. You have to show that they were, it wasn't a choice. Like, so for example, I have a son who is autistic and he qualifies for SSDI. He's working a little, but he qualifies for SSDI. But, if he was just a normal teenager who didn't want to get a job, we're not going to say, well, we recognize that being a teenager is hard. If he didn't have this magical diagnosis, right, that crosses him over from the lazy to the disabled, then we wouldn't see him as worthy of support.
I definitely see many examples of that today in society. Lastly, as someone with little knowledge in law, I found it really challenging to find information that makes law digestible. And I was wondering if you could recommend any resources for people looking to understand their rights or cases going on around them.
So at one level, on the one hand, it's really easy to find the Constitution. It's actually really easy to actually find case law, but you have to know what you're looking for. And that's where it becomes a lot harder. So like Cornell, for example, has a legal institute. It's a website, LII, and on it, you can find every single Supreme Court case ever. You can find, you can find all the codes in all the states, but that's not going to necessarily help you understand it. I think that on reproductive health in particular, there are some good third parties. Like I believe I could be getting this wrong, but I think like the Goodmacher Institute is one. They're a policy institute that has a focus on reproductive health policy. They work worldwide. They've been in existence since the 1960s, and it is guttmacher.org. Now they are pro reproductive rights, so they are going to have, some would say, a left-wing slant on things. But they would probably be the first person. Like I know they're big on just reproductive health and abortion, and they study it all over the world. They track policy, they track they track lawsuits, they track things like that. So that's specifically what you're interested into. Like that's who I would go to if I was going to look up this topic. If you're more generally looking for things on the Constitution, there's so if you want to see like the state of play in front of the Supreme Court, for example, now it's not just the Constitution, but that's everything they do. There's a good starting point called SCOTUS blog. So Supreme Court of the United States, SCOTUS blog.com. A law firm started it. And it's a really good like starting point, like what's going on at the court right now, what's really mattering to the court right now. And they also house an archive of all the Supreme Court cases with little thumbnails about their decisions, with actual text of rulings, but also all the briefing. So if you ever want to know who's arguing what or why on a particular case, that's a great place to dig in. They do a really good job of pulling together all the like news coverage on a case, for example. But again, that's focused on the Supreme Court itself. beyond that, there's just like a bunch. It gets much more broader and fragmentary after that. So it would really depend on like again, and I think the biggest problem, and Natalie, this is an issue for everybody. On the one hand, Franklin Delano Roosevelt said, for example, every American should read the Constitution and the Declaration of Independence. These are critical documents. Everybody should know them. But they're almost impossible to know without a grounding in what they mean. So, again, little plug, if we, at least in PIA, we have two classes. We have constitutional law and civil liberties. But look for things like that. Look for websites that are overtly trying to do civics education. That was a big push of Sandra Day O'Connor when she left the Supreme Court. There's an organization called the American Constitutional Society, or ACS. Now, again, I will admit the ACS is left of center. Okay, if you want the very right of center version of it, look at the Federalist Society. But there are groups like that they're full of constitutional scholars. But I guess my encouragement to you is like SCOTUS blog is great if you already know like that there's an issue. Like so if you see something come up in a news feed, go look at them. If it's a Supreme Court case, if but more generally, like I said, it's a function of you've got to start curating those sources. Because again, we also live in this era. Like I could tell you, Vox, for example, has dedicated columnists to the courts. Okay, so does the Washington Post, so does the New York Times, so does the Wall Street Journal. But I can tell you that, for example, like I wouldn't read Vox because they're always got their hair on fire. It's always about how everything's going to destroy everything. Slate does the same thing. Slate and Salon, they get a lot of things about, oh, this case might destroy your entire life. I don't know how you balance that out. So I understand it's hard.
Well, thank you for coming on today. That was the last of my questions, and thank you for diving into such complex topics with us and for your time. And thank you to all the listeners for following along this week. That was our episode on IVF in America. Next week we'll have Annika talking about IVF in other countries. And I hope you guys stay tuned.